4 counts of murder contrary to sections 171 and 172 of the Penal Code Act, Chapter 128. In count 1, it is alleged that Christopher Okello Onyum on the 2nd day of April 2026 at Gaba Early Childhood Development Center, Gaba Trading Zone, Gaba Parish, Makinde Division, Kampala District, with malice aforethought unlawfully caused the death of Teku Gideon. In count 2, it is alleged that Christopher Okello Onyum on the 2nd day of April 2026 at Gaba Early Childhood Development Center, Gaba Trading Center, Gaba Parish, Makinde Division, Kampala District, with malice aforethought unlawfully caused the death of Keisha Agenroth Otim. And in count 3, it is alleged that Christopher Okello Onyum on the 2nd day of April 2026 at Gaba Early Childhood Development Center, Gaba Trading Zone, Gaba Parish, Makinde Division, Kampala District, with malice aforethought unlawfully caused the death of Seryange Ignatius. And count 4, it is alleged that Christopher Okello Onyum on the 2nd day of April 2026 at Gaba Early Childhood Development Center, Gaba Trading Zone, Gaba Parish, Makinde Division, Kampala District, with malice aforethought unlawfully caused the death of Odeke Ryan. The burden and standard of proof, the burden to prove the allegations made against the accused person lies on the prosecution, and the standard of proof is beyond reasonable doubt. Under the Constitution, the accused person is presumed innocent until he pleads guilty or until he has been proved guilty by the prosecution. In this case, the accused person pleaded not guilty on all counts, thereby putting all the burden on the prosecution to prove his guilt beyond reasonable doubt. And this burden does not shift. Proof beyond reasonable doubt does not mean proof beyond any shadow of doubt. Yeah, and in a case of murder like this one, prosecution bears the burden to prove the following ingredients. Please pay attention. 1, that there was death of 4 people, namely Teku Gideon, who is in count 1, Keisha Agenroth Otim in count 2, Seryange Ignatius in count 3, and Odeke Ryan in count 4. That their deaths were unlawfully caused, that whoever caused their death did so with malice aforethought. That is to say, he had the intention to kill, or the knowledge that the act would result into the deaths of these 4 children. And lastly, that the accused person caused or participated in the unlawful deaths. Proof of the ingredients. Death may be proved by post-mortem reports, the person or persons who saw the dead body, and those who attended the burial. In this case, in order to prove this ingredient, the prosecution adduced the evidence of Dr. Katongole Abdul, prosecution witness number 1, who performed the post-mortem examinations on the bodies of the 4 deceased children. That is Teku Gideon, Keisha Agenroth Otim, Seryange Ignatius, and Odeke Ryan, who confirmed that the 4 children were dead. The respective parents of the children, namely Apollo Stella, PW2, Komakech Marvin, PW3, Mbazira Lawrence, PW4, and Okrut Simon, PW5, the parents of the deceased children, respectively, also confirmed that the children were dead and buried. The evidence of the caretaker, Namtevi Phoebe, who is PW6, and the coordinator of the daycare center, Miss Annette Agoye Odongo, who is PW7, also testified to the death of the children. And the evidence of the district CID officer, Kabalagala, SRIT James, PW15, and the evidence of the scenes of crimes officer, PW14, they all talked about seeing the dead bodies of the 4 children. 1 dead body was at the center, which they called the primary scene, and the 3 dead bodies were at Wenzi Medical Center, and they called that the secondary scene. Unlawfulness as an ingredient. All homicide cases are presumed to be unlawful unless accidental or authorized by law. And Namtevi Phoebe, Miss Annette Agoye, testified on how the attack on the children was done. The district CID Kabalagala and the Soko, scenes of crimes officer, described the primary scene of crime, which was Gaba Early Childhood Development Center, where the crime is alleged to have happened, and the secondary scene being Wenzi. And the SOCO, the Scenes of Crimes Officer, took photographs of both scenes, including the photographs of the dead bodies, which you had an opportunity to look at in Exhibit PEX 10. Malice aforethought. This is a state of mind which may not be proved using direct evidence, but circumstances surrounding the case. It may be inferred from the nature of injuries, the type of weapon used, the part of the body on which the injuries are inflicted, prior planning and prior threats, and the conduct of the accused person during, prior, and after the incident. In this case, the prosecution adduced the evidence of PW1, Dr. Katongole Abdul, who examined the 4 bodies of the deceased and described the injuries on all the bodies of the 4 children were on the necks. And he concluded that the cause of death for all the children was hypovolemic shock due to deep cut injuries to the neck, and the same were caused by sharp objects. Miss Namtebi Phoebe, PW6, and Miss Aneta Goyo Dongo, PW7, the eyewitnesses to the crime, saw and identified the weapon used as a knife. Namtebi Phoebe stated that she saw the accused throw the knife over the chain-linked fence. The knife was later recovered and was admitted as a prosecution exhibit. The other witnesses testifying to the injuries on the body of the deceased were the district CID, the division or CID officer Kabalagala Esserite James, who is PW 15, and the scenes of crime officer, who is PW 14. In his report, you looked at that report. Malice aforethought may also be inferred from the evidence of prior planning. Prosecution adduced evidence of Namtebi Phoebe, PW6, regarding the visit of the accused person at Gaba Early Childhood Development Center, that's the primary scene, on the 1st of April 2026, that is a day prior to the date of the offense. And also evidence of PW18, who analyzed the phones of the accused persons and other electronic devices and established that the accused had previously used his phone to make Google searches for kindergartens, daycare centers, play centers, among others. Accused participation. This may be proved by direct or circumstantial evidence, or both direct and circumstantial evidence. Direct evidence is where there are eyewitnesses to the crime who state that they saw the accused person commit the crime. Circumstantial evidence, on the other hand, is evidence from the surrounding circumstances of the case. The circumstances must be such that they point to nothing else than the guilt of the accused person. Prosecution adduced the evidence of Phoebe Namtebi, PW6, and Aneta Goye Odong, PW7, who testified that they saw Okello or Onyum Christopher, the accused person, cutting the 4 children inside the premises of Gaba Early Childhood Development Center on the 2nd of April 2026 at about 11 a.m. or thereabout with a knife. Esserite James, PW 15, the divisional CID officer of Kabalagala, and the SOCO, Scenes of Crimes officer, responded and found when the accused had been arrested within the premises by Cyrus and Moses, security guard who was at the church gate. The accused was detained in the guard house of Gaba Early Childhood Development Center to keep him away from the angry mob that had gathered, and they rearrested him. There was DNA evidence, also PW 17, which revealed that the DNA of the accused person was actually found on the hand of the knife, which was recovered behind the scene. And both the report and the knife were admitted. There was also the DNA evidence also found some of the DNA from the bodies of the children on the clothes of the accused person. I will talk about contradictions and inconsistencies. There may be contradictions and inconsistencies in prosecution evidence. There are those contradictions and inconsistencies which are minor, and those should be ignored. However, if there are grave contradictions and inconsistencies that go to the root of the matter, those ones will lead to the discrediting of the evidence, and it will not be relied on. I will now turn to the defense case. the defense of the accused person must be weighed against the prosecution's evidence. In this case, the accused gave an unsworn statement and called two witnesses in his defense, DW2 and DW3. The accused did not expressly deny causing the deaths of the 4 children, but he repeatedly stated that he did not do so intentionally or deliberately. Although his evidence was lengthy, it may be summarized as follows. He did not act intentionally or deliberately, and although there were claims that he was completely mentally okay, there may have been other mental challenges that may have gone undetected that could have contributed to the death of their children. He said he was not mentally okay. He also denied being forward-minded in the killing of the children. In respect to this, he made reference to the book about the war, which was part of the evidence of PW18, who analyzed his flash disk and found that he had saved a book entitled Sun Tzu on the Art of War. He said that that book or file was saved long ago and it cannot be said to apply to the killing of the children. He also denied being deliberate and with forethought while making reference to the evidence of the searches he made using his phone as testified by PW18, and specifically the search for ISIS beheading and for schools that teach young children. He said that whereas these searches suggest that he did it deliberately, but other factors were forcing him to make those searches. He further stated that he was under the control of some people whom he said were in 3 categories. And the accused person further stated that between January to March, he entered into an especially distressing period because he was contending with some people who were surveilling him, made many demands from him, and they threatened to kill him. They began demanding for money, and he notes that they had all the capabilities, and they were following him closely. As a result, he left the neighborhood of Bunga, where he was staying, and started sleeping on the streets. He stated that as a result of this, he tried to end it some way and somehow, and tried a few things to bring the whole thing to an end. He tried to flee the country, he tried to rob a bank, and also tried to kill his brother's family. He then said those people whom he at times referred to as his friends during his testimony had to do with his actions of the second. He stated that court should not honor the charges for murder because there were some circumstances that forced him to act the way he did on second. That is the day of the incident. The accused also kept on denying the claim that he caused the deaths of the 4 children for human sacrifice, and insisted many times that he was coerced to make those statements. However, you will recall that the plain and the charge and caution statements were never brought as prosecution evidence. You will also realize that some of his statements would have required some more explanation from him, but because he gave an unsworn statement, he had to give his story uninterrupted and without assistance from his lawyers. From the above evidence of the accused person and from some of the questions during cross-examination of some of the prosecution witnesses, the accused seems to raise a defense of insanity and or diminished responsibility. The law presumes sanity under Section 10 of the Penal Code Act. It provides that, and I quote, every person is presumed to be of sound mind and to have been of sound mind at any time which comes in question, until the contrary is proved. Earlier on, you heard the prosecutor saying this. Every person, all of us here are presumed to be sane until the contrary is proved. Section 11 of the Penal Code Act provides that a person is not criminally responsible for an act or omission if at the time of doing the act or making the omission, he or she is through any disease affecting his or her mind, incapable of understanding what he or she is doing, or of knowing that he or she ought not to do the act or omission, although his or her mind is affected by disease, if that disease does not in fact produce upon his or her mind one or other of the effects mentioned in this section in reference to that act or omission. And diminished responsibility is defined in section 177 and subsection 1 of the Penal Code Act, which provides that where a person is found guilty of murder or being a party to the murder of another, and the court is satisfied that the person was suffering from such abnormality of the mind, whether arising from a condition of arrested or retarded development of mind, or any inherent causes or induced by disease or injury has substantially impaired his or her mental responsibility for his or her acts and omissions in doing or being part of the murder, the court shall make a special finding to the effect that the accused person was guilty of murder, but with diminished responsibility. Subsection 2 thereof provides that on a charge of murder, it shall be for the defense to prove that the person charged was suffering from an abnormality of mind, as is mentioned in subsection 1. You will also be expected to review the evidence regarding the lifestyle, the conduct, and/or behavior of the accused person before the incident on April 2nd, 2026. This evidence can be found in the testimonies of his two landlords, one in Bunga, that is PW 9, and another in Chanja, PW 10. It can also be found in the testimony of PW 8, the car rental, the person who gave him or hired to him the car. The vehicle, you looked at the vehicle, you know the registration number. The officer who analyzed the CCTV footage, PW 18 who analyzed the accused person's electronic gadgets, Miss Namtevi Phoebe PW 6 who interacted with the accused on the 1st and then on the 2nd of April. Also Miss Annette Odong who interacted with the accused person very closely a few minutes before the attack. You may also consider for your guidance evidence of two doctors, Dr. Roger Agenda of CKR IHK Kampala, who made a psychiatric and mental examination of the accused person on the 30th of December 2025 at the request of the accused person. And then evidence of Dr. Emmanuel Nwamanya, PW 11, who is a police surgeon but at the same time a psychiatrist, who did a mental examination of the accused on the 7th of April 2026. Ladies and gentlemen assessors, you had the opportunity to listen to all the prosecution witnesses. You also listened to the defense evidence. You should be able to form your opinion in light of the legal principles that I have explained above and advise the court on whether you believe that the prosecution's evidence adduced has proved the case against the accused person beyond reasonable doubt in light of the defense that he has raised. If you find that the prosecution has proved its case against the accused person beyond reasonable doubt on all counts, you will advise me to find the accused person guilty of the offense of murder